Moving on, next topic. Landlord tenant rights in Florida. Can the landlord actually shift all the responsibility for the repairs and maintenance onto the tenant? Hi guys.
This has pretty much been explained.
Jonathan Daly. Florida Statute 8351 puts certain obligations on the landlord. That is the main structural components of the home, the floors, roof, walls, plumbing, heating, cooling, etc. However, the statute was changed somewhat recently to include that this portion of this section of the Florida statute is modifiable for duplexes and single family home residences. So it's kind of a gray area in the law right now in Florida. It's troubling because there's not a lot of case law on it. So here's the argument. The argument is that there is still a warrant of habitability that the landlord owes constitutionally by public policy to the tenant. So they warrant that the house will be habitable. But the statute does say specifically it is modifiable. The Florida statute that provides for the habitability warranty. So if you sign a lease that says you will handle all repairs and maintenance as a tenant, then arguably you're supposed to. There's a strong constitutional and public policy argument that that provision in a lease where it puts all repairs, all maintenance, no matter what, structural, wall, your roof caves in on the tenant, that is unenforceable because, let's be honest, rule of public policy, it makes no sense to put all the maintenance and repairs on the tenant because at that point, what is the responsibility of the landlord? There is none. And the tenant essentially is responsible for everything. Their rent pays for the mortgage. Their only option at that point, if they sign a lease that puts all the repairs and maintenance on them, their only option, if their roof caves in or the car drives through your wall, their only option at that point is just to terminate the lease. And if that lease provision is enforceable, then the landlord could argue that they have to fix it before they can even leave or terminate. So that just doesn't make any sense. It basically makes a complete unilateral contract where it's just unconscionable, not fair to the tenant at all. But that is what the statute says. So you need to hire a lawyer and have a good lawyer that can make a good public policy argument because there's really no case law on the issue. And arguably the statute does say it is modifiable. So if you're in a duplex or a single family home and you've signed a lease that says you will handle all repairs and maintenance, then that is that. You need to have a really good lawyer. Otherwise, just don't sign a lease that says that. You need to be clear and have a clear maintenance section of the lease that dictates the maintenance and repairs and who is responsible for what.
Stay informed and get the latest legal tips, news, and insights. Don't forget to like, follow, and subscribe to all our pages. Make sure you hit that notification bell so you get updated anytime we upload a new podcast. Come get your dose of excellence on a daily basis.